Julius Malema's name has appeared 77 times at the Madlanga Commission. Every single time his name resurfaces, he organizes a public gathering to insult the people trying to expose him, denying everything completely. But yesterday, he was nailed. General Khan, his very close ally, completely threw him under the bus. If General Khan goes down, Adriano Mazzotti and Julius Malema are both going down with him. In this video, I'll show you exactly why. Dear viewers, grab your cup of coffee, sit back and relax, because today we are going to expose the biggest corruption scandal the mainstream media doesn't want you to see. Please do us a favor. Hit that like button, share this video, subscribe, and turn on the notification bell. In South Africa, the law only catches certain people while others walk free because of their political connections. If you think everyone should be treated equally before the law, type justice for all in the comments section below. Let's echo this message to the world together. Jabulani, roll the clip.
Seated here, it's a man called Adriano Mazzotti. And more said, I'll ask them to stand up, because these are the two and part of their partners who have given us money on the day we were launching the EFF. When the IEC asked us to pay for money, me and Floyd had nothing. We looked at each other in the eyes and said, what is going to happen? At that time, they asked for 650,000, and we had no means, none whatsoever. Later to be told through a telephone call, Mazzotti has got a very unique voice. Brother, the money is paid. Then we knew that we were good to go. That is how the EFF was allowed to contest the first election in 2014. We are very proud of Adriano Mazzotti and are not ashamed to associate with him. We don't know his business because he's not our business partner. He donated money to the EFF like all of you who bought tables here. We never asked you, what do you do for your business? We just declared. We declared because it was not a secret that the money was donated by Adriano Mazzotti. So we do not run an underworld, we are running an above world. And do not be scared that we are part of anything Mazzotti does. Mazzotti has never been arrested. Neither has Mazzotti ever been charged. I've been charged. I've been arrested. I've seen the door of prison for my political beliefs. My properties were taken by SARS. I was thrown to the streets.
People from IDEC, is it inclusive of that list that we did before?
Yeah, no. IDEC, we have gone past that stage because they are in the consultations. These names which we are doing are names of people who must come for consultations.
Okay, no, thank you, Chair.
Okay.
Chair.
Honorable Malema.
I would really want to get a motivation on General Khan, because I don't understand what General Khan was not there was nothing solid that suggested he should be brought to our attention. I'm just saying because the concerns about long lists are also real concerns. And if there are people who can do without, I think we should consider that. Because what Mkwanazi said was, Mokhodzi said, ask Khan, and I suspect it was Khan who told Mokhodzi, because Khan is a member of that committee. But Mokhodzi never said I was told by Khan, and General Mkwanazi never confirmed that Khan told anyone about that. So it was more or less about his own suspicion, because someone who was in that meeting could have as well said, no, ask him to ask Khan, because Khan was also with us in that meeting. And that one says, no, ask Khan. So there is nothing fundamentally that suggests that really we need General Khan. I don't know. I hold no brief from General Khan, but I'm just saying, if MK insists on the name, that's fine.
You have. I've got the same, I've got contacts here. Some I even forgot, but I don't call them. I don't share any sensitive information with them unless those people are known to me and I'm confident and I know that I can describe my relationship with those people. Let's say, for instance, I've got General Sibia's number, like I do with many generals and ministers and deputy ministers. But I can't claim to be a friend, and Sibia can't claim to be my friend. But I know him. I will call him on matters of the police that I think, look, there is this issue and it seems like you're not paying attention and anything of that sort. I can't deny that, but to stretch it to comradeship, to stretch it to friendship, none of us can claim that kind of a relationship.
Julius Malema never knew a day like this would come. In the first video, he openly stated that Adriano Mazzotti was the one who gave him the money to register the EFF. This is the exact same man who was completely exposed at the Madlanga Commission. This is the same man who was running an illegal tobacco business. The same man who was evading tax but had so much money to register a political party. This same man was exposed paying high-ranking police officials and politicians to help him secure tenders. In the second video, General Khan was supposed to appear before the Ad Hoc Committee for investigation but was shielded by Julius Malema. In the third video clip, you can see Julius Malema claiming he has General Sibia's number and the numbers of many other police officers. This might not make any sense to you right now, but hold on a little bit, watch the next video, and you'll see how Julius Malema, Adriano Mazzotti, and General Khan were jointly running a criminal empire within the police service. Jabulani, roll the clip.
Nyatlo affidavit. Carnilinx has carefully considered the allegations contained in the affidavit deposed to by Nyatlo. To the extent that those allegations concern Carnilinx, they are denied. Carnilinx respectfully submits that portions of the affidavit appear to conflate historical regulatory matters, unresolved tax disputes, media reports, and industry commentary with evidence of present-day criminality. Those concepts should be carefully distinguished. Historical regulatory matters and ongoing tax administration processes cannot, without more, establish present-day criminal conduct. Likewise, unresolved tax disputes cannot be equated with findings of fraud, tax evasion, or organized criminal activity. Under the heading SAPTA, Ipsos, and industry material. Carnilinx notes that portions of the Nyatlo affidavit appear to rely upon publications issued by industry organizations and market reports prepared by third parties. Carnilinx respectfully submits that such material should be approached with appropriate caution. Industry bodies perform an important role in the public debate. However, they are not independent regulators, courts, or investigative authorities. Their publications frequently reflect commercial interests and policy positions. Likewise, retail pricing studies and market surveys may identify pricing trends or market anomalies. They do not establish whether excise duty has been paid in respect of any particular product. Nor do they establish whether a manufacturer has committed tax evasion, fraud, smuggling, or any other criminal offense. Carnilinx further submits that media reports, publications produced by representative organizations, and market studies are each different forms of material carrying different evidential weight. While such material may contribute to public debate, it does not constitute primary evidence of criminal conduct. Serious findings against any person or corporate entity should be based upon reliable, independently verifiable evidence properly before the Commission. Under the heading, Carnilinx's interaction with law enforcement. The Nyatlo affidavit further suggests that Carnilinx improperly utilized organs of state against competitors. Carnilinx unequivocally denies those allegations. Carnilinx, like any responsible corporate citizen, Carnilinx has, where appropriate, reported information concerning suspected unlawful conduct to the relevant authorities. There is nothing improper in providing information to SARS, SAPS, or any other competent authority. Once such information is provided, all investigative and enforcement decisions remain those of the relevant authority acting under its own statutory powers. Carnilinx has never exercised control over the investigative functions of SARS, SAPS, or any other organ of state. Conclusion. Carnilinx has made these submissions voluntarily because it believes that the Commission should have before it the company's own account before reaching conclusions that may affect its reputation and commercial standing. Carnilinx does not seek to minimize its history or avoid scrutiny, nor does it ask the Commission to determine disputes between itself and SARS concerning historical tax matters. Those matters are regulated by legislation and remain subject to the statutory mechanisms provided by South African law. Carnilinx asks only that its history be understood in its proper statutory, factual, and commercial context. The question presently before the Commission is whether there exists credible, reliable, and independently verifiable evidence establishing the allegations presently made against Carnilinx. Carnilinx respectfully submits that those questions should be answered on the basis of evidence relevant to the issues before the Commission and not by inference drawn solely from historical regulatory engagement, unresolved tax disputes, media reporting, industry advocacy, or commercial rivalry. Carnilinx has voluntarily approached this Commission because it believes that the search for the truth is best served when all relevant perspectives are placed before it. It respectfully trusts that these submissions will assist the Commission in fulfilling its constitutional mandate fairly, objectively, and in accordance with the rule of law. Carnilinx remains willing to cooperate further with the Commission and reserves its right to supplement these submissions should additional information become relevant. Yours faithfully, Adriano Mazzotti, and then there are two annexures, A and B, that were referred to in the letter. So the letter, so Chair, now you see why I first went to the answering affidavit and those paragraphs, because what Mr. Mazzotti is taking issue with is the reliance on what he describes as media reports that are not based on independent evidence, not based, as far as he can tell, on the affidavit itself, and that the affidavit that the Commission put up also included industry-obtained analysis, research analysis, like the Ipsos study, which was commissioned by Carnilinx's competitor. It was commissioned by British American Tobacco. So that's fine. We accept that. What I wish to do, however...
Have you touched on the fact that they also say some of the material is historical, which I understand to mean and is no longer applicable?
Well, it's historical in the sense that the admissions that were made by Mr. Mazzotti took place some years ago. But it's not historical when looked at in the perspective of this Commission about particular conduct. And it's not just about Carnilinx as an entity. It's about Mr. Sayed, who's a director of Carnilinx. So it relates both to findings against Carnilinx of illegal tobacco trading, not based on media reports. And I will go to Mr. Mazzotti. But in a nutshell, what you'll see is that the affidavit contains admissions by Mr. Mazzotti, both personally and as a representative of Carnilinx. And these admissions relate to past customs, excise and tax non-compliance, failures to account for cash income, and failure to pay tax, VAT, and excise duty. A particular transaction, which I can say because we've been given permission, the illegal Pieterse transaction. But again, I'm not going to go into detail, but the commissioners will see it as we look at the affidavit, which concern manufacturing cigarettes off the books. Then there's admissions of unlawful importation of tobacco under a false Swaziland pretext. There's admissions of unlawful surveillance of SARS officials and access to personal records. There's an admission of obtaining a confidential SARS document for cash, so paying someone inside SARS to get access to this document. And there's also admissions of improper cash payments to legal advisors. And it's clear from the affidavit, and it's explained by Mr. Mazzotti, that the cash payments were made on the belief that SARS officials were being paid off, and that by making these cash payments to these legal advisors, they would assist in resolving Carnilinx's problems with SARS. But I must also say that in the affidavit, Mr. Mazzotti also says the following, that, and I'll come to it, that he believes he was naive to think that the SARS officials could be bought. He's very careful to say that. So let me go to the affidavit. The settlement agreement, as I said, was concluded on a different basis, on unlawful conduct, but a different unlawful conduct. Chair, the affidavit, the SARS bundle is CJC 361, and there's one file. Carnilinx was registered and operated lawfully to date. For example, in paragraph 18, to date, the company has always made the payments due to SARS on time and accurately, except as mentioned below. In 19, the company has also abided by the requirements of VAT and income tax, except as itemized below. I don't think it's necessary for us to go into the individual instances of this conduct. I've set out already for the commissioners the topics that they cover. So if I may skip over those, they are under different headings, but as you go through it, you'll see that they relate to what I've said about evading income tax, excise duties, VAT, illegal trading in relation to the Grindling heading. It concerns the payment of cash for certain benefits, and again, also cash payments to avoid tax. Infiltration of SARS. And I'm just going to scroll past these. There's the purchaser engagement. I just want to point out that, and commissioners, you'll see throughout this is not just an conduct that was undertaken by Mr. Mazzotti on his own. He did it in concert with Mr. Mo Sayed and with Mr. Phillips. For example, when you look at paragraph 51, he says, in February 2013, Petersa approached me with an offer which I discussed with Sayed and Phillips. We accepted his proposal, which was wrong and has landed our company in trouble, and in retrospect, we should never have done this, and then he describes the arrangement in some detail. He goes on in paragraph 54 to explain the 8 million rand in cash that they were able to raise in this engagement that was not accounted for in the books of the company. And he then explains what he used the 8 million rand for. In paragraph 61, it's clear that he accepts that Carnilinx acquired tobacco unlawfully and wrongfully of 2 tons per week over a period of time. He goes on to explain further contraventions of the law, and he says the unlawful conduct. And here's where he deals with payments to legal advisors. And Chair, what's important about this is that we're no longer talking about tax non-compliance. This affidavit has moved off tax non-compliance at this point. It's talking about fraud and corruption. I'm not going to mention the names of the legal advisors that are named in the affidavit. He does say in relation to at least one of them that you'll see in paragraph 83 of the affidavit. That he persistently referred to his contacts at SARS and in particular mentioned Johan van Lochrenberg and Ivan Pillay. We were naive to believe that he could influence van Lochrenberg and Pillay to favor our company. This we accept now is in a manner of speaking nonsense and that we were misled. But in the process, we paid 800,000 rand in cash to this legal advisor. And so on, Chair, Commissioners, to the end of the affidavit. And you'll see at page 52 of the affidavit, again, I'm not sure what page it is in your bundle, is the signature and the date on which it was commissioned, 6 May 2014. The settlement agreement ultimately concluded is at page 83 of your bundle when you're ready, although we're not going to go through it in detail, Chair, unless you wish to. Chair, I see you reading, so I'm just waiting for you.
No, please go ahead.
So it's at 83, but at page 98 of the settlement agreement, the date of the signature is 27 October 2020, and it was signed by the directors. Of Carnilinx and 2 of the directors and a SARS representative. And that agreement is, really what it does in a nutshell is it records SARS's position and view that the cigarettes, that cigarettes manufactured by Carnilinx were presented on paper as having been moved and exported lawfully, but that there were no documents to prove a lawful export. So the effect was that SARS treated the cigarettes as having been diverted into South Africa without customs duties, VAT, etc., being paid.
Mr. Sim, I think it's only right, perhaps fair, that you also put on record paragraph 1.1.3 of that settlement agreement. It mentions two specific individuals against whom this debt is raised, and therefore not everybody who is a director or shareholder.
Yes, Commissioner Beloy, it says that the amount in dispute means the debt raised by SARS against Carnilinx, the company, of which Mr. Mazzotti, Mr. Phillips, and Mr. Sayed are directors. So it's against the company as well as Phillips and Mazzotti in their personal capacities.
Thank you.
The amount in dispute is about 31.5 million, but the settlement agreement concluded on basis of 25 million and something. So those are, that is the factual basis of the allegations of the conduct of Carnilinx. And then the directors who are engaged in, in that unlawful conduct. The allegations, well, the admissions in the affidavit of fraud and corruption, we have no knowledge of anything further coming of it, whether there were any charges, whether there was any action that was taken. It's not within SARS jurisdiction to follow up on those.